watching the award-winning GHS-TV, Germantown Community Television, your hometown news and information station.
Welcome back. With us now is Bill Jones. We are talking about bankruptcy law. Bill, we've basically covered Chapter 7 and Chapter 13. Now, I know with both of these bankruptcies, you've got to go to a meeting of the creditors. How does that function exactly?
The way that the process works from beginning to end is you're going to go into an attorney's office. When you go in and you interview your attorney, just like he's interviewing you, you need to make sure that these are folks that are going to have time for you. These are folks that are going to talk to you. They're going to give you an information packet. We all have to have the same information to make our petition. You're going to fill out your petition. They're going to file it. Within 2 weeks of filing, you're going to be given a first meeting of creditors date. Now you have to go. It can only be continued one time. If you fail to show for either, it's going to be dismissed. What the first meeting of creditors is it's a time where the trustee, you and your client can go, and if there are any creditors that have questions about your petition, they'll be there at that meeting, and they can ask your clients questions. Generally what happens is we all kind of know the rules. We all kind of know how it works. Generally, folks don't really show up. It doesn't make sense to pay an attorney to go down and ask questions on a case where it's a foregone conclusion what's going to happen. But a lot of times what you'll see is those reaffirmation agreements that I'm talking about. The creditors sometimes will show up at those meetings and ask your clients, or ask you if your clients would like to sign those reaffirmation agreements at that time. A lot of times a 341 meeting is some of the only interaction that an attorney and a client will have with the court system during a bankruptcy. Unless there are some other motions which we talked about, a motion to suspend payments. But a 341 meeting of creditors a lot of times will be the only interaction there is with the court.
Okay. What are some alternatives to bankruptcy?
There are a lot out there. There are a lot that I would tell you to steer clear from. There are a lot I would tell you to look into. You can go to if you've got a credit card debt that someone's trying to collect from you. There's an animal where you can go to the General Sessions Court, if you're here in Shelby County, and file a motion to make payments. Perhaps you could do it that way. You could make payments on this debt and pay it without having to file bankruptcy. The nice thing there is you've got a judge saying, yes, these are what the payments are going to be. You're not at the mercy of some collector that's calling you on the phone saying, hey, let's work out an agreement. Those things can go south. You can work out an agreement with a collector on the phone, and they can come back at a later date and sue you for the balance. I like it that a judge gets to make that payment plan. So I would suggest if that's the option that you're going to go, that you go down to General Sessions Court, make a motion to file payments. Probably what I've seen the highest success rate is with people that genuinely want to pay off their debt and pull themselves out from the cusp of bankruptcy, is Dave Ramsey's Financial Peace Plan. A lot of the local area churches put it on. You can find them out, I'm sure, on the internet. He's got a plan. Basically, the gist of it is that you pay off your lowest debts first, regardless of interest rates. And then whatever that payment on that lowest one was, you roll it over into your next payment. And you keep doing that and doing that. And it kind of just builds up like a snowball where by the end of it, you should be putting everything you were paying on all these credit cards, you should be socking into your house. And ideally, you'll pay off all your debt real quick. That's probably the best alternative to bankruptcy that I've heard. But again, it only works if you're willing to do it. Just like a Chapter 13 only works if you're willing to make those payments.
Now, if there's no alternative and you've got to file bankruptcy, how long does that stay on your credit score?
That's going to depend. It's going to depend upon whether or not you file a 7 or whether or not you file a 13. It's also going to depend upon the reporting agency. I generally tell my clients to plan on it being on their credit report 7 to 10 years. Now that's a long time, so you need to be prepared for that. You may want to do some bankruptcy planning. If there are items that you know you need to purchase that you can't purchase with a hurt credit score, you may want to consider that before you go in and talk with an attorney.
Okay. And how often can you refile?
Again, that's going to depend upon which chapter you file. Generally, you're looking at 8 years. However, if you file a 13 and then you fall out of it, you miss a payment and it's dismissed, you can then go in and refile. But if you successfully complete it, you're going to need to wait 8 years.
Okay. Now, you hear a lot on the radio and TV about debt consolidation agencies. Now, I mean, what do those guys do, and are they even worth talking to?
This is actually one of my favorite topics, but I'm not going to lambaste anybody, get myself in some hot water. What I will say is this: read the fine print. Go to an attorney, get them to read the fine print. It is worth the money going to consult with an attorney. What I've found, generally, and I'm just speaking in broad terms, what I've found to be the truth is that these companies advise you to miss payments. Most of the time, these credit card companies won't work with you on settling a debt unless you're late. So you can be current on a credit card, and these companies will tell you you need to miss 1 or 2 payments, and once you do that, then they'll negotiate with us. So they're telling you, in some cases, to actually become delinquent so you can negotiate it down. Now, they have no vested interest in whether or not you settle this debt. So if you miss a couple of payments, then they can't negotiate it down. You're left holding the bag. I've got more information on my website. It's midsouthbankruptcy.com.
All right. Our time is up for this edition of Legalese. I would like to thank our guest for taking time out of his busy schedule to be with us and sharing his thoughts and insights. If you would like more information about Legalese or any other program on GHS TV, please refer to our website at www.ghstv.org. Thank you for joining us today, and be sure to join us next time for more discussion on legal topics. Until then, I am Vince Perryman. Thank you for watching.